All right, we can go ahead and get started. So we'll start off with brief introductions. My name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project, and my pronouns are she, her.
My name is Nick Hudson. I'm a senior manager of policy and advocacy at the ACLU of Texas. My pronouns are he, him, and tonight we're here to break down what's really going on with the issue of bail in Texas and why you should care about it.
Yep, exactly. So I'll give a brief layout of what this conversation will look like. First, we want to talk about the pretrial system in general, kind of what happens before you even get to the bail hearing, which is a lot of what we'll be talking about tonight. And then we'll also talk about some of the myths that you may have heard about bail. We'll be busting those myths. And then we'll end with some of the bills that have been introduced that have passed the Senate, have made their way into the House, and will be soon voted out by House members, probably the end of this week, and voted on by next week. We'll also ask you guys, like, tell you guys how you can get involved. Like, we're just not, this isn't just us talking at you. Please, like, interact with us, ask questions as we're talking, and then I'll make sure at the end we try to address everyone's questions.
Thanks. And so before we jump into the bills and everything else, we just want to kind of zoom out and imagine you're watching our justice system from 1,000 feet in the air. And Kirsten, can you just describe what's happening at this stage in the process that we're talking about tonight?
Yeah, so before you get to the bail hearing, it really starts with an interaction with law enforcement. So, say you're accused of an offense, it's likely that somebody called 911 and law enforcement showed up on the scene. At that point, they start their investigation. They start questioning everybody who's anybody on the scene. The person accused is going to get asked some questions. The complaining witness, which is the person who the alleged harm happened to, is going to get asked some questions, and anybody else who was like a witness to what happened. Usually, that is kind of like the bare minimum of the investigation. Law enforcement may also take pictures if there is something to take pictures of. If you can think about like the most serious offenses like murder, they're probably going to take pictures of like the crime scene or whatever. And so law enforcement, they do their investigation. And at that point, they have a lot of discretion. They get to choose whether they're going to let you free or whether they're going to arrest you for the thing that you've been alleged of. If they choose to arrest you, they will put handcuffs on you. You have your handcuffs behind your back, and then they're going to escort you into the back of their police car. At that point, they drive you down to the local station, and there you get out of the car, and that is kind of where everything starts. So you get there, you have to have your mugshot taken. I'm sure you've seen folks' mugshots just spread all over the media. You have to have your fingerprints taken. They'll ask you to change into jail clothes. So they'll tell you to take your clothes off. They'll give you the jail clothes. They'll take off anything that you have on your body, cell phone, keys, anything that's on your person. They'll confiscate that and keep that until you're released. And at that point, under Texas law, you have 48 hours to be seen by a judge for the judge to determine whether there is enough evidence to hold you before trial, and whether or what bail they're going to set in that situation. So imagine you're in this cold room for 48 hours. You're either brought up to the judge like in person, or a lot of these courts or a lot of these jurisdictions are doing virtual bail hearings where they'll just zoom in. And so at that point, you're in front of the judge, the magistrate, or the judge, interchangeable terms, and they're determining whether there is enough evidence. The legal standard is probable cause. Probable cause is a very, very low standard. A lot of the times, the only evidence that the prosecutor has at that time is the police report. And the police report goes back to the police investigation. This is what the police says happened, basically. And at that point, what the police officer is saying happened is kind of treated like law when it comes to probable cause. There's usually no other evidence. And so the judge will look at the police report and any other evidence if the prosecutor has it. And then they'll usually look at the person's criminal history, their ties to the community. And when they're looking at all of this, in addition to determining whether there's probable cause, they're also determining determining if they determine that there's probable cause, that there's enough evidence to hold you. They're also determining whether they're going to release you or not pending trial. So a judge has three main options. They can require you to pay an amount. This is called a cash bond, cash bail. They can release you on a personal bond. This just means you do not have to pay any amount of money to be before you were let out of jail pre-trial. And then they can no bond you. This means that the judge is saying you do not get a bond. This last one, this no bond happens in very limited cases, usually capital offenses. That middle one, the personal bond, a lot of people think that this is a get out of jail free card. It's really not. In majority of cases, you have some other type of restrictions put on you, whether that's an ankle monitor, whether you have to check in with pretrial services. It may be a stay away order that says if you come within this amount of feet of the person that said you did this, cause this harm to them, you can be jailed. And so there are all these restrictions that judges put on folks. Even if they do get a personal bond. And at these one thing that I failed to mention, at these hearings, it is just the prosecutor, the judge, and the person being accused. It is very, very rare in Texas for a defense attorney to be there representing the person being accused. There are, I believe, 3 counties where defense attorneys are given to the person being accused and they're on site advocating for that person. But imagine being the person accused in that situation. It's a pretty imbalanced system where the judge is telling you whatever you say can be used against you. So you may not say anything. You may not even advocate on your own behalf because you don't want to mess up your case. But the prosecutor said this person did this. You can't even really defend yourself, and you don't have anyone there defending you. And so, yeah, I'll leave it at that. I think there's a lot to say about the bail hearing, but that's the general.
And the decision at this bail hearing to decide whether to release you or keep you jailed is what the entire conversation about bail is about. Whether you're going to be held in jail or released pending your trial. And it's a really serious decision. And let's also just think about who's in our jails right now on any given day. More than 70% of the people in our jails are detained pre-trial. They are presumptively innocent. They have not been convicted of an offense, of the offense for which they're being detained. It's more than 53,000 people locked up pre-trial on any given day. Most of them are held pre-trial not because of an individualized assessment by a judge about safety or the risk of flight, but because freedom in Texas nearly always hinges on your access to money. And people who are in jail before trial are there mostly because they can't afford bail in Texas, a monetary amount set by the court for someone to purchase their freedom. And I'll pass it over to Kirsten.
Yeah, I'll also add, like, just think about the impact that that has on an individual. Just spending 1 day in jail, 2 days in jail, like most people spend more than a couple of days in jail. That's your car might be repossessed while you're sitting in the jail. You lose contact to your family while you're sitting there. You may even lose your job. You don't show up the next day. You have the type of boss who tells you, yeah, you didn't show up, no call, no show, you're fired. So these are permanent repercussions for sitting in jail, putting somebody in pretrial detention. So these decisions shouldn't be taken lightly. Um, yeah, I'll leave it at that. I want to like keep talking, but I'm like I don't want to get too deep into certain things. Oh,
Yeah, and
and
I'll
I also one thing that I want to mention is that a report that Nick actually released earlier this year showed that Black and Brown people are more likely to have higher bonds than their white counterparts for the same offense that they're being accused of. So there's also racial disparities in these decisions.
major racial disparities. You're more likely to have a higher bail amount. You're more likely to be stuck in jail if you're Black or brown in Texas. And it's largely because of this wealth-based detention system. Texas has a two-tiered system of justice where if you're wealthy, you get to go home and enjoy the presumption of innocence and fight your case. But if you're poor, you remain in jail, and it's really hard to fight your case. And this system hurts all of us. First, because anyone in Texas can be accused of an offense. Texas has more than 360 exonerations. It's the highest of any state in the country. We get it wrong sometimes. And so this unjust wealth-based system is always a looming threat to every single Texan, to you and your family and friends. Anybody can be accused of an offense. It also affects all of us because people who are held pretrial unnecessarily are not just, they're more likely to be convicted, they're more likely to get longer sentences. There's societal costs. They are less likely to bounce back when they get out. And it's because of the coercive nature of pretrial detention. Many people will plead guilty just so they can go home to their families. They may just accept the conviction, even on an offense for which they are innocent, just so they can do time served and go home. It's a very common thing. All the research says one of the key determinants of whether you're going to be convicted is whether you are detained pre-trial. It is just much harder to fight your case. It's harder to build your defense from a jail cell. And meanwhile, if the human costs were enough, Texas is spending $1.2 billion a year jailing people who haven't been guilty before the government has had to put any evidence up, before anyone's had a chance to defend themselves in court. And most of these people, the research says, pose no threat to public safety. There is no good reason to be detaining 53,000 people in Texas per year. Texas is getting it way wrong. And releasing people pre-trial when it's safe to do so, letting them keep working, care for their families, fight their case, and just like someone who is wealthy, has the ability to do, that's what justice really looks like. And so let me just ask Kirsten, I know we wanted to talk about do some myth busting. So should we talk about some of the common myths around bail and pretrial detention?
Yeah, definitely.
So first one is people in jail in Texas are guilty. I think we covered some of that, but what do you think?
Yeah, I'll just reiterate the points. I see like some folks are just joining. Um, Again, like the determination on whether you are going to be free pre-trial and during your trial hinges on probable cause. Probable cause is one of the lowest legal standards that there is. It really is just based on a lot of the times what the police officer said you did, that bare minimum investigation that we talked about at the beginning of this call. And so at these bail hearings, judges are not determining whether you're guilty or innocent of the offense that you're being accused of. They're determining whether there is enough evidence, and they have to look at that probable cause standard. And again, it's very low. So it really is like if the officer says you did it, if the report says you did it, it's really hard to fight that, especially as somebody who does not have a defense attorney present to advocate for them past what is already being said in the report.
So how about this one? The bail, everyone thinks about money when they hear the word bail. You have to have money involved in the bail process in Texas or in anywhere.
Yeah, I talked a little bit about this when I talked about when judges release somebody on a personal bond. Again, that's not a get out of jail free card. That's saying you get to go back to your community while you fight your case. And while you're in your community, you may have a GPS monitor on you, you may have an ankle monitor on you. You may have to check in with pretrial services every so often, may have a stay away order that says you can't be within a certain amount of feet of the person that has accused you of this offense. And so there are other ways to promote public safety outside of cash bail in more humane ways to do it.
Great. How about this one? So people, most cash bail is not a big problem. Most people can get out without having to dig into their wallet.
So majority of the people, Vera actually did a report. Folks do not have a rainy day fund that can cover something like this, where you've been accused of a crime and the judge is asking you to put down $1,000 to get released. A lot of people do not have $1,000 saved up for to get out of jail. That's just the way, especially in this economy. And then another thing that their report found is that judges are setting cash bond in over 83% of these cases. So again, like there's this idea that judges are just letting people out and they're, going and committing all these offenses, and these activist judges are doing these things. And that's just not true. Majority of the people who are in jail because they cannot afford the amount that the judge has set in those 83% of cases.
Yeah. And like median bond amounts are like 10,000. So like,
Mhm.
like 1,000 be like relatively affordable, and like bond amounts are way higher. It's often impossibly high. So Kirsten, what about this one? Pretrial detention keeps communities safe. I think we keep hearing that from people like the governor and Senator Upton and other folks in the legislature. What do you think about that?
Yeah, it's actually it's doing the opposite. Um, you have somebody being accused of an offense, you're jailing them based on this scintilla of evidence, the police report, and then the person is sitting in jail for days. Each day that person sits in jail, the more unpinned their life becomes. Um, Again, you miss one day of work, you can get fired. And so, what are you supposed to do after you've gotten fired? Like maybe in a lot of the cases that we've seen, prosecutors will drop the case because there's not enough evidence or for other reasons they just don't want to prosecute it. But at that point, the damage has already been done. You've lost your job. You may have lost custody of your children, and the state is not doing anything to get you back whole. They've already, allowed these things to happen, and there's nothing to say, okay, like let's find you a new job. If anything, now it's become harder for you to find employment because you have this charge on your record. A lot of people don't know that even when a case is dropped by a prosecutor, that arrest charge is still on your criminal history. You have to go and seek out an attorney or represent yourself to get those charges removed from your criminal history. Those will show up if a criminal background check is done, even if the prosecutor said there was not enough evidence to prosecute this person.
And so I just wanted to hit on, the governor, Governor Abbott has talked about a package of bills that they're working on. They're calling it bail reform. And I just wanted to underscore that this package of bills, SJR 1, SJR stands for Senate Joint Resolution. So Senate Joint Resolution 1, SJR 5, and SB 9, these are not bail reform. These are proposals that would roll back all of our rights. They would jail legally innocent Texans, not because they are dangerous or a flight risk, but because they are poor and because of who they are. It's a costly attack on the idea of innocent until proven guilty, on due process that will overcrowd our jails, and without making us meaningfully safer. And so real bail reform, what that would look like is that it would protect both safety and liberty. And it would mean that ensuring people, if they spend time in jail, it's only because they pose a serious and unmanageable risk or won't show up to court, and they can only be detained after a really fair process for the best of reasons. Because taking away someone's liberty before trial is it's one of the most severe deprivations of liberty we have in our society. And so some of the protections we need to see if they're going to deny bail to people are ensuring that people have lawyers at these appearances in court. We need to make sure that we're using tools like text reminders to make sure we're reminding people to get to court. So we're using the least restrictive possible conditions to get people into court, that we're expanding citation in lieu of arrest. We're keeping detention reserved only as a last resort in the most serious cases after genuine due process. And so I'll pass it back to you, Kirsten.
Yeah, so I guess we can start talking about the bills themselves. So there's been a package of bills, as Nick mentioned, they're being coined bail reform, and I hate that because they have completely co-opted what true bail reform looks like, and what has been called bail reform for years now has been co-opted by the other side, and now there's some confusion about, oh, well, I guess it's good, it's bail reform, right? No, 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 no. These are regressive bail bills that we'll be talking about today. So I'll pass it to Nick to really start off with the constitutional amendments, SJR 5 and SJR 1, and then I'll touch on SB 9, which is the other bill.
Great. So SJR 1 and SJR 5 are proposed amendments to our state's constitution. So these would adjust your constitutional right to be free before trial. And so they deal with the right to change, your right to bail under our state constitution. And I'll just start with SJR 5, then we'll go into SJR 1. And SJR 5 is a proposed change to the Constitution that would expand the government's power to jail people before a trial. And right now, Texans are presumed innocent and they have a right to bail unless they're charged with something truly extreme. But SJR 5 would let judges deny bail outright in a a much wider range of cases, included some charges that sound violent, but often aren't, like certain aggravated assault offenses with a deadly weapon could mean merely threatening somebody with a flashlight. Um, and part of the problem is SJR 5 just doesn't guarantee fairness in these hearings. They don't guarantee people a lawyer at these critical hearings. They don't require genuine evidence of a real safety risk, a threat to a real person. It doesn't require judges to consider alternatives to detention first, like ankle monitors or stay away orders or scram monitors that monitor for alcohol. So what we're talking about doing in SJR 5 is locking up people before trial without legal representation and without a real assessment of safety in many cases. And that's a big shift away from the due process that our Constitution and laws promise. And it could put thousands of more legally innocent people in jail before trial. So what we'd say is Texans deserve real safety, not policies that look tough and just punish people based on accusations alone. This bill has already passed the Texas Senate, but to change the Constitution, you also need two-thirds support in the Texas House. That means they need 100 votes to pass it. That means 51 lawmakers sticking together, standing up for meaningful fairness and due process in our any changes to our state constitutions, bail laws. They can stick together and do that. I'll now hit on SJR 1. It is one of the most dangerous proposals in the bail package. It's one of the most radical because it would automatically deny bail. Bail in the United States is supposed to be carefully limited. You're supposed to make individualized assessments. SJR 1 would automatically deny bail to anyone accused of a felony if the government claims they are, quote, an illegal alien. I'm using their language because that particular definition in the bill is deeply flawed and overbroad. It could include, as currently drafted, U.S. citizens, DACA recipients, green card holders, asylum seekers, just because of how they entered the country. We have a lot of people working in immigration spaces who know nothing about immigration law. And it's a big problem, separate from the threat to automatically deny bail, which is really inconsistent with what the Constitution requires. Judges wouldn't need to hold a full hearing, consider individual circumstances. Bail denial would be automatic, based only on your immigration status and not your risk to safety. So look, this is unconstitutional. It violates due process and equal protection. It puts local judges in the impossible position of making these really complex immigration determinations. It will put sheriffs in the position of needing to let some people that they might think may be more risky out because they have to hold people under SJR 1. It also pushes the cost of detention onto counties, swelling local populations in the jails and fueling, frankly, private prison profits, in part because many counties, their jails are just overfull, and they are starting to send people to private facilities in Mississippi and Louisiana, where some Texans have died pretrial. And look, this bill is not about public safety. SJR 1 is not about public safety. It is about scapegoating immigrants and turning pretrial detention into a political weapon. SJR 1, like SJR 5, has already passed the Senate. But again, 51 members of the Texas House can stand together and stop it and defend the right to bail under our state constitution. I'll pass it to you, Kirsten, to talk about SB 9.
Yeah, and I'll also add, like, the immigration determination. We've been in rooms with immigration attorneys, and I don't know about you, Nick. They've explained to me over and over and over how the immigration system works, and it is a civil system. And I'm confused every single time. Like, they lose me every single time because it's just that complex. Immigration law is not something to play with. So also add that. So I'll go ahead and talk about SB 9. SB 9 is an extension of a bill. So this bill is authored by Senator Huffman. It's an extension of a bill that Senator Huffman passed in 2021 when Governor Abbott was again pushing for bail reform. During that year, SB 6 passed, and one provision of SB 6 said that if a person is accused of this list of offenses, it was a list of offenses in the code, then a judge cannot give that person a personal bond, meaning a judge must require that person to pay some sort of money, some amount of money before they are released pretrial. And judges have come out and said, defense attorneys have come out and said, this is the reason that our jails are so crowded now, because that bill made it to where a judge's hands were tied. Their discretion was limited in those cases where a person was accused of a certain offense. And it wasn't about public safety. It wasn't about whether this person is a threat to public safety or whether they're a flight risk. It was simply because that person is being accused of this offense. Again, going back to that probable cause determination with the smallest amount of evidence, and the judges couldn't do anything. They had to set some amount of money under that bill, um, in order for somebody to get out. And so SB 9, the bill that we're talking about tonight, is an extension of that. And Huffman has went back and added even more offenses under that provision. One of the offenses that we're really worried about is terroristic threat. And so I know we have some lawyers on the call, some defense attorneys. Terroristic threat, oftentimes the folks who are charged with that offense are people who are homeless and people who are experiencing some type of mental health issue or mental health episode. And so our jails are already jam-packed with people who do not deserve to be there and who are there simply because they were having a mental health episode or they're homeless and they may have been trespassing, so now they're in jail. And so this terroristic threat offense we're really, really worried about. It is actually a misdemeanor. And so under SB 9, if you're charged with terroristic threat or any of the other offenses listed, even if this is your very first time committing any type of offense, you have a clear criminal history, this is your very first time being accused of something, you have to pay whatever amount the judge sets in that case before you are released pre-trial. And so that's very, very dangerous. It's an expansion of the wealth-based system that we've talked extensively about today. And then there's a lot with SB 9, but I'll only mention one more thing that we're really worried about. Another provision in SB 9 allows a prosecutor to appeal a bail order. The bail order is like the uh, magistrate judge or the judge's decision on bail. They said this person has to pay this amount. It allows for a prosecutor to appeal that to another judge if they feel like the bail amount is insufficient. Very subjective determination. It gives the prosecutor way too much power. Mind you, prosecutors can already challenge these bail decisions at these hearings. And so it's just giving them much more power, because what SB 9 also says is if you are in jail when that prosecutor appeals your bail order, you have to stay in jail. Let's take a pause right there. That's insane. You have to stay in jail, even though the judge has already said, I set your bail at this amount, but because the prosecutor has appealed your bail order, now you have to sit in jail. That is not that is not how the system is supposed to be run. We trust our judges. We elect our judges and trust them to make these decisions without them being appealed and people sitting in jail while those appeals are happening. So those are our two main concerns with SB 9.
And so I'll just say, like, what's the big deal? Like, why are we talking about here these bills? These are some of the biggest threats to Texans' rights we've seen in a long time. And um, we need everyone's help, because your freedom in America and in Texas shouldn't depend on your bank account or your birthplace. And we are working together, and we need your help to stop these terrible proposals. I'll pass it to Kirsten to talk about what you can do and how you can be involved.
Yeah, so these bills can be stopped, as Nick has already said. They need to. We've done extensive amount of work on these bills since February of this year. We have been boots on the ground, going to every House member, um, and telling them our concerns and letting them know the harm that these bills will cause to their constituents. But now they need to hear from you. I think a lot of lawmakers really won't move. They really won't do what we're asking them to do unless they hear from the people who voted them in. Because at that point, it's the threat of them not being reelected. And so they need to hear from their constituents, and they need to hear why their constituents are concerned about these bills. And so we've laid it out tonight. We have extensive resources on our page. So TCRP, we posted a post earlier with a petition. All you have to do is go and click on that link that's in our bio, and it'll take you to a page that already has this information typed out for you. You can put your name, put your first and last name, your email, and like your address. It'll find who your representative is, and then at that point, you all you have to do is click a button to email your rep. You can also call your representative and tell them about the concerns that you heard tonight.
And like, if they don't hear from you, they don't know that this matters to people. There are so many bills that a little bit of work, a few phone calls, your action on this can make the difference. We have a few questions. Kirsten, do you want me to ask one of them, and one of us can take
Sure.
it? Whichever. So the first question we have is, has anyone ever been made whole after an event like this? I assume after pretrial detention. Like say they found out you were innocent, what recourse do you have?
So another civil rights lawsuits that you can file, but for a large majority of people, like there is no recourse. The damage is done, and they're expecting you to just go on about your day. I don't know if you have anything to add, Nick.
Yeah, I'll just say when people don't have the money to pay, they'll go to a for-profit bail bondsman. Whatever money you pay to that bondsman, even if you're found not guilty, even if a prosecutor drops your case the next day, you're never going to see that money again. In the course of doing this work at the Capitol, we've met many, many people who have mortgaged their homes, dipped into their savings, borrowed money from family and friends, only so they could get their family member out during the pendency of that trial. They're never going to see that money again. Some of them were innocent. There's a member of our coalition who spent a year in jail for a crime she didn't commit, held only on a $30,000 bond, was trying to be a parent from jail. I don't think people are made whole after events like this, and there's no way you could sue the county and get money for the time you spent incarcerated for the crime you didn't commit. It's part of what makes this entire thing so unjust. You're not going to get that time with your family back. You may not see your kids grow up. You may lose your job and never be able to get that back. The collateral consequences are enormous.
Yeah, we have another question from Christina. Why are they giving more power to the entities with the most resources? Prosecutors have more resources than the accused. I mean, you made the point, Christina. Prosecutors have a lot of power, a lot of discretion on what they're going to do with your case. And yeah, it's a completely unbalanced system. I think you hit the nail on the head, and we're opposed to that provision of SB9 specifically because of that.
One more question we have, what can we do to raise awareness about the cash bail system when we're not in session?
It's a good question. I think we are a part of a larger coalition that does this work. If you want to join the coalition, like, hey, please join us. I think we'll be doing an extensive amount of work during the interim. I know before this session, Nick did a lot of work on preparing the materials that we now use to advocate against these bills. He drafted up an amazing brief. I will implore y'all to check it out. It's on the ACLU website. But yeah, the work never stops, honestly and truly.
I would say I think that people underestimate the influence of raising a concern with their own lawmaker or their own county commissioner's court or with their own local judges. I mean, you have judges in your community you can talk to, county court law judges, criminal district court judges, the presiding judge in your community. You have to find out who represents you, and that can be a little tricky sometimes, but you can do it, and I highly encourage you to do that. Talk to them about your concerns about this. They are hearing only from folks that Abbott's sending their direction, talking about tough on crime stuff, this really unbalanced perspective, and your voice would be really welcome balancing it out. Separate from the individual action you can take, there are lots of groups doing really good work to raise awareness about the cash bail system that you might consider getting involved with. other organizations. There's a group in Houston called Pure Justice. His organizing project has a group in the Dallas, San Antonio, and in the Houston area, and they may have other places too, but they're a great group to get involved with if this concerns you. And then if you want to hear more from either TCRP or the ACLU of Texas, sign up on either of our websites. We're at aclutx.org, and we would love to plug you into work going on in your community and across Texas. At the moment, though, what I'm saying is the most important thing you can do is to reach out to your lawmaker and use the TCRP link and call your lawmaker and ask them to vote against SJR 1 and against SJR 5 and SB 9 unless they make fundamental radical changes. And we really appreciate anyone who can do that.
Yeah. I also say at TCRP, we're always looking for volunteers, and that link is also in our bio. All right. Any last minute questions? When is the deadline to call? Yesterday. Playing. We are hearing that the bills can be heard as early as next week. We're honestly not sure. There's kind of like a lot of we're hearing a lot of different things. There was a press conference held by Greg Abbott today, and he said that he's also proposing more negative changes to the bills. And then Senator Huffman said negotiations are over with. And then the House author of the bill said that negotiations are still happening. So we really don't know where the bills are, but it's our understanding that they will likely be heard on the House floor next week. So the quicker, the better. If you can call tomorrow after work or during your lunch break, email, the email petition takes less than 2 minutes. If you can do that tonight, that's great.
I see another question. Do they ask follow-up questions when we call in case we're not confident we have all the answers? They might. And I would just say, if you don't know the answers, just say so. It's okay to not know everything. What you can do is talk about why this issue matters to you and your values and your experience and why you joined this call. I mean, something brought you here tonight. It might have been just you were scrolling through, but I would just say, talk about what you know and tell people that you oppose these bills, and that is plenty, and we would really appreciate it. It can make a difference.
All right, I think we addressed all the questions. Thank y'all so much for joining us tonight. Please feel free to reach out to TCRP or ACLU if you have any follow-up questions. We're always free to help and to answer and kind of help you navigate this process. It's not an easy process to navigate, but we can really change this state if we stick together and push against some of these harmful bills.
Thank you, Kirsten, and thanks to TCRP for hosting us tonight.
Thank you. Y'all have a great night.